This module builds on prior discussions of CCNRs, liens, and homeowner association restrictions by focusing on easements and encumbrances, which are legal interests that affect real property without transferring ownership. Easements and encumbrances are commonly revealed through title reports and surveys and can significantly impact property access, use, financing, and marketability. Arizona real estate licensees must understand how these interests operate in order to meet disclosure obligations and protect their clients from legal and financial consequences. Encumbrances and their effect on real property. An encumbrance is any claim, lien, right, or restriction that limits an owner's ability to freely use or transfer real property. Encumbrances run with the land, meaning they remain attached to the property even after it is sold. Encumbrances fall into two broad categories: financial and non-financial. Financial encumbrances include mortgages, deeds of trust, property tax liens, judgment liens, mechanics liens, IRS liens, and HOA liens. Non-financial encumbrances include easements, deed restrictions, CCNRs, encroachments, and rights of way. While encumbrances do not convey ownership, they can cloud title or restrict how the property may be used. Easements as non-financial encumbrances. An easement is a non-financial encumbrance that grants a person or entity the legal right to use another person's land for a specific purpose without owning it. Easements commonly allow access for utilities, roads, shared driveways, irrigation canals, or maintenance corridors. Easements remain in effect even when ownership changes and are typically disclosed in Schedule B of the preliminary title report. Because easements limit how land may be used or developed, buyers must be made aware of their existence prior to closing. Easement appurtenant. An easement appurtenant involves two parcels of land: the dominant estate, which benefits from the easement, and the servient estate, which is burdened by it. This type of easement runs with the land and automatically transfers with ownership of the dominant estate. A common example is a shared driveway or access road that allows one property to reach a public roadway by crossing another property. Easements appurtenant are typically created by written agreement and recorded to provide notice to future owners. Easement in gross. An easement in gross benefits a specific person, company, or organization rather than another parcel of land. These easements are most commonly held by utility companies, irrigation districts, pipeline operators, and railroads. Unlike easements appurtenant, easements in gross do not automatically transfer with the sale of the property unless expressly assigned. Even though they benefit an entity rather than land, easements in gross still run with the burdened property and must be honored by future owners. Prescriptive easements. A prescriptive easement is created through long-term use rather than a written agreement. In Arizona, a prescriptive easement may arise when someone uses another person's property openly, continuously, and adversely, without permission, for at least 10 years. The use must be visible and uninterrupted during the statutory period. If permission was granted, the use is not hostile and cannot become prescriptive. Prescriptive easements are often unrecorded and can be discovered only through physical inspection or investigation of historical use. Easement by necessity. An easement by necessity arises when a parcel becomes landlocked and access to a public road is required for reasonable use of the property. Arizona law implies this type of easement based on fairness and the presumed intent of the original grantor. Even if the easement is not written into the deed, courts may recognize it to prevent land from becoming unusable. Easements by necessity typically arise after a division of land that unintentionally cuts off access. Creation and termination of easements. Easements may be created through express written grant, implication from prior use, necessity, prescription, or condemnation through eminent domain. Once created, Easements may be terminated only under specific conditions, such as merger of ownership, written release, abandonment, or expiration, if the easement was granted for a limited duration. Because easements can significantly affect property value and use, proper recording and disclosure are essential. Voluntary and involuntary encumbrances. Encumbrances are also classified as voluntary or involuntary. Voluntary encumbrances are created with the owner's consent, usually to secure financing, such as mortgages, deeds of trust, and home equity loans. Involuntary encumbrances arise without the owner's consent and include property tax liens, mechanics liens, judgment liens, IRS liens, and HOA liens. Property tax liens in Arizona automatically attach on January 1st and generally take priority over other liens. Encumbrances, title, and disclosure responsibilities. Recorded encumbrances provide constructive notice to the public, meaning buyers and lenders are legally presumed to know they exist. Title companies identify encumbrances during the title search, and sellers must resolve or disclose them before conveying marketable title. While some encumbrances, such as utility easements or HOA restrictions, are common and acceptable, others must be cleared before closing. Recording false or groundless documents that purport to affect real property is prohibited under Arizona law and may result in damages and attorney's fees. Role of the Arizona real estate licensee. Arizona real estate licensees have a duty to review preliminary title reports, disclose known easements and encumbrances, and explain how these interests affect property use, access, and value. Failure to properly identify or explain encumbrances can result in disputes, financing delays, or legal liability. A strong understanding of easements and encumbrances allows licensees to guide clients confidently through transactions, while remaining compliant with Arizona statutes and commissioner's rules.